in respect of the additional 27 posts. One of the key contentions in this petition is that the creation of the office of the CAS did not adhere to the principle of public participation for the 27 additional posts. We've referred to the Supreme Court case in British American Tobacco Kenya PLC versus CS for the Ministry of Health and two others. The sequence of events that led up to the establishment of the office of the CAS are captured in the affidavit of Simon K. Rotich, the PSC's CEO's officer's response in the ELRC petition number E174 of 2022 and relied upon by the LSK in the instant petition, and the affidavit of Felix Koskei, the head of public service. The PSC on 19th of September 2022 received a letter from the then head of public service, Joseph Kinywa, informing it of the President's proposal on the establishment of the office of the CAS in the public service. The correspondence set out the history of the office and the justification for its establishment. Considering this, the President proposed that the office of the CAS be ranked in the public service within job group CSG3. Further, that one position be established in each ministry except in the Ministry of Interior and Coordination of National Government, that would have two positions in light of the scope and significance of the portfolio mandate. The letter also listed the job description for the CAS and relevant qualifications. The PSC, at its weekly meeting on 21st of September 2022, discussed the proposal, where it was observed that the office had been established in January 2018. However, the process of establishing the office was declared unconstitutional in the Okia case for lack of compliance with Articles 10, 47, 132, 201, 232, and 234 of the Constitution. In view of this pronouncement, the PSC resolved to abolish the CAS office established on 24th of January 2018, comply with the dictates of the judgment in light of the President's request, and conduct public participation. In this regard, the PSC via a press advertisement on its website and the local dailies dated 21st of September 2022 invited members of the public to submit their views on the proposed establishment of the said position, and to do so by 6th of October 2022. The PSC, in its response dated 11th of October 2022 to the President's letter dated 19th September 2022 through its chairperson, Anthony Mushiri, divulged that following the public participation exercise, the PSC received 498 views. Out of these, 3 were requests for particulars, 108 were applications for appointment to the position of CAS, and 161 were in support of the establishment of the office, while 226 were opposed to the establishment of the office. In a nutshell, the reason for opposition was that the office had been declared unconstitutional, a bloated wage bill, the resultant economic burden to taxpayers, and that the role was a duplication of the CS and PS. The PSC considered and analyzed the responses, and in the end, noting that the conditions of Section 27 of the PSC Act and public participation had been complied with, recommended establishment of the office as proposed. Following this conclusion, the office of the CAS was established via a letter dated 11th of October 2022 as communicated by Joseph Kinywa, the then head of public service, to the PSC chairperson, Mr. Mushiri. It is revealed further through the affidavit of Felix Koskei, the head of public service, in a letter dated 24th of April that on 23rd of February 2023, the President wrote to PSC seeking a review of the complement of CSSs within the public service to vary from one in each ministry to one in every state department. On the same day, PSC CEO Simon Rotich wrote to the PS Chris Kipto seeking concurrence on the availability of funds to meet the resultant expenditure of the additional 27 posts. The PSC, in response to the President's letter, consented to this variation in its letter dated 27th of February 2023. In the letter, PSC noted that the consent was based on workload attendant to the role of CAS and National Treasury's confirmation of funds. Following this communication, the President increased the complement of the office with additional posts. The PSC was then asked by the President to recommend persons to be appointed, which it did. Moreover, in response to a letter dated 18th of October 2022 and two letters dated 10th of March 2023 by the PSC, the SRC wrote a letter dated 14th of March to the PSC advising it on the job evaluation, grading and remuneration and benefit structure for the position of CAS in the public service. Soon after, the 2nd to 51st interested parties were nominated on 16th of March and appointed by the President on 23rd of March 2023. Two things are clear from the foregoing account. First, the initial proposed number for the office was 23. It is discernible that the process of public participation that was undertaken by the PSC was with reference to the letter from the President to PSC dated 19th of September 2022, which only requested for 23 posts. On the flip side, the sequence and procedure that led to the establishment of the 27 additional posts did not adhere to the constitutional principle under Articles 10 and 232 of the Constitution and conditions set under Section 27 of the PSC Act. This process, in our opinion, did not satisfy the guiding principles set out by the Supreme Court in the BAT case. We say so because, as a guiding principle, public participation must be real and cover all forms of governance. It is noted that the public submitted comments in the public participation exercise based on creation of the CS office in each ministry, not each state department, as indicated in the President's letter dated 23rd of February 2023. It was incumbent upon the PSC to prove that the public participation exercise covered all the additional 27 nominees. This was not done in accordance with the BAT case, and in essence, based on the record before us, it is evident that PSC failed in its mandate. The undeniable conclusion is that the process of establishing the extra 27 posts was unconstitutional.
I'll go straight to the next issue. Did the President and the PSC have the power to create the current office of CAS in the manner in which it was created? The consolidated petition requires us to interpret a number of articles in the Constitution. We are well guided by Article 259, which provides as follows, and I shall not read it. The principles governing interpretation of the Constitution are well settled. The Supreme Court, in Communication Commission of Kenya, and 5 others versus Loyal Media Services and 5 others, stated that the Constitution should be interpreted in a holistic manner, within its context and in its spirit. In Lena Conchera and others versus Chief Justice of the Supreme Court of Kenya and others, the court restated the principle that the Constitution should be given a purposive interpretation where all provisions are read as a whole, with each provision sustaining the other. The following passage appears in Gatirao Peter Munya versus Dixon Mwenda Kitheji and two others in Supreme Court Petition number 26 of 2014. I shall not read it. This principle was restated by the Court of Appeal in Attorney General versus Royal Society of Kenya and four others, 2018, and a number of other decisions that we have considered. I shall not read them out. The Supreme Court in Samuel Kamau Macharia and another versus Kenya Commercial Bank Limited and two others held as follows, and I quote, "At the outset, it is important to note that a constitution is not necessarily subject to the same principles against retroactivity as ordinary legislation. A constitution looks forward and backward, vertically and horizontally, as it seeks to re-engineer the social order in quest of its legitimate object of rendering political goods." I shall not read the rest of that paragraph. Applying those principles to the matter at hand, we find further as follows. The history of the office of CAS is fairly recent, having been first established on the 24th of January 2018. However, on 20th April 2021, the High Court in Okiya Mtata Okoitil and another, Supra, declared the office to be unconstitutional. That decision was stayed by the Court of Appeal in Public Service Commission and 72 others versus Okiya Mtata and 4 others. The main appeal is still pending. In granting the stay, the learned judges of the Court of Appeal found, and I quote, that public interest underpinning the substratum of the intended appeal would demand that we affirm the interim orders in terms of prayers 2 and 3 of the application issued on the 15th of June 2021, and which we hereby do. Cost of the application to abide the outcome of the intended appeal, unquote. To fully appreciate the terms of the order of stay, we looked at the wording of prayers 2 and 3 of the appellant's notice of motion dated the 29th of April 2021, brought under Rules 5, 2B, and 47 of the Court of Appeal Rules. They were couched in the following terms. 1. That pending hearing and determination of this application, there be a stay of the judgment and order of the High Court, Murima J, made on 20th of April 2021. For the avoidance of doubt, pending the hearing and determination of this application, the offices and the individuals currently holding the offices of Chief Administrative Secretary, Cabinet Secretary, and Principal Secretary shall not in any manner be affected by the judgment on order, and the Honorable Attorney General shall not be required to file an affidavit in the matter within 30 days of the judgment or at any time. And 2, pending the hearing and determination of this application, the High Court shall not take any steps in enforcing the judgment or order made on 20th April 2021 in High Court Constitutional Petition number 33 of 2018 as consolidated with High Court Constitutional Petition number 42 of 2018. For the avoidance of doubt, pending the hearing and determination of this application, there be a stay of proceedings before the High Court, and an order do issue that the Honorable Deputy Registrar shall not schedule the matter for mention, and the High Court shall not mention the matter to issue any further orders, unquote. It is our considered opinion that the above stay did not reverse the findings or declarations or orders of Murima J, that the office of CAS as then constituted was unconstitutional. The learned judges only granted a stay of execution in the terms of prayers 2 and 3 that we have set out above. Furthermore, the main appeal is pending. We have then closely studied the decision of the Employment and Labor Relations Court in Law Society of Kenya versus the Public Service Commission and the Honorable Attorney General, Petition 174 of 2022. The respondents have relied on that decision for their proposition that the learned judge, Baru J, found the advertisement calling for public comment and the creation of the office to be lawful. We fully appreciate that we cannot review or stand on appeal over a decision of a court of concurrent jurisdiction. However, we are also alive to the fact that we are not bound by the decisions of Murima J and Baru J above. The suit before the ELRC was challenging the validity of the advertisement by the PSC dated the 21st of September 2022, inviting public views on the establishment of a new office for CAS. The petition was dismissed. For the avoidance of doubt, the prayers as set out in the face of the judgment were: a declaration that the advert of the first respondent dated 21st September 2022 is illegal and irregular for violation of Section 27 of the Public Service Commission Act 2017 insofar as it fails to include fundamental details under the said Section 27 subsection 1 to enable the public to make meaningful and informed contributions towards the establishment of the office of CAS. B, a declaration that the advert of the first respondent dated 21st September 2022 is illegal, irregular, and unconstitutional for violating Article 201, Sub-Article D of the Constitution, as it seeks to establish an office in the public service with duplicity of roles as that of principal secretary, contrary to the principles of public finance. C, an order that the said advert of 21st September 2022 be declared a nullity as it fails to provide crucial information that enables the public to make informed contributions in the establishment of the office of CAS. D, an order that the first respondent be required to provide information provided for under Section 27 subsection 1 of the PSC Act in any public participation before the establishment of public office. And lastly, E, each party to bear its own cost. The learned judge of the ELRC interpreted the stay by the Court of Appeal in Public Service Commission and 72 others versus Okiya Lomtatal and 4 others as follows. The first respondent, PSC, took into account that after the Court of Appeal stayed the High Court judgment addressed above, parties then reverted to the position subsisting prior to the judgment, unquote. The learned judge then went on to find that all the legal parameters for establishment of the office were met. It is imperative to note that the Law Society of Kenya did not appeal the dismissal of its petition by the Employment and Labor Relations Court. We are cognizant